Calvin Barry. I formerly was a senior Crown Attorney prosecutor for in excess of 15 years. I am a defense criminal lawyer with in excess of 20 years experience. I wanted to talk about something you may have read about in the newspaper or media outlet, the interlock provisions under the provincial regulatory statute that affect your driving prohibitions. The old law was that if you were found guilty either by guilty plea or after trial of impaired over 80, refused to provide a breath sample, or failing to provide a breath sample, you'd be looking at a 12-month prohibition after guilty plea or trial if you're found guilty. And then the second year you'd have to take a back on track program, and also you'd have to install an interlock device in your vehicle in the second year as two preconditions to getting your license back from the Ministry of Transportation. What has happened since August 2010 is that there's a new regime where if you come under one of the two streams, I'll call them Stream A and Stream B, the following will happen. Stream A, 3 months of no driving, followed by 9 months of the interlock device. Stream B, 6 months of no driving, followed by 12 months of the interlock device, for a total of 18 months. If you're found guilty before August 3rd, 2010, you do not qualify for either stream. If you're found guilty between August 3rd, 2010, November 1st, 2010, it's Stream A. Guilty plea after November 1st, 2010, within 90 days of the offense date, Stream A. Guilty plea after November 1st, 2010, outside of 90 days of the offense date, Stream B. Trial after August 3rd, 2010, Stream B. And all agreements regarding the interlock device lease and other paperwork must be completed within 90 days of the offense date. Now, what are the minimum qualifications? You can't have a situation where you're impaired by a drug and alcohol, and the person would have had to enter into a lease agreement for an ignition interlock device and completed a preliminary assessment with the Ministry of Transportation. If within the 5 years of the offense date you've been convicted of an alcohol-related offense under the criminal code, impaired, refusal, fail to provide a sample, over 80, then you would not qualify. And the offense cannot have a situation where there's death or bodily harm. The Crown may not wish you to be eligible, or the Ministry will find you ineligible if there's an accident, if the readings are quite high, for example, over 160 milligrams of alcohol and 100 milliliters of blood. If you have a bad highway traffic abstract, many speeding convictions, or if you have a criminal record that shows a disregard to follow court orders. This, to be eligible, of course, you'd have to plead guilty or be found guilty. You'd have to admit that you were guilty of a criminal offense. Fingerprints and photos would be on your record. Prospective employment opportunities would be a problem. Traveling to the U.S. and abroad, and the fact that you have a prohibition, versus if there's tribal issues, there's charter issues, there's constitutional issues, and you want to have a trial and you want to plead not guilty so you don't have to have one of these devices in your vehicle, then you may want to have a trial and fight the matter with somebody that has had experience with these type of allegations and earn yourself an acquittal. And then you don't have to have any type of prohibition, you don't have the insurance issues, and it's essentially like it didn't happen. I thought it was important because this new legislation came into force August 3rd, 2010, so you would understand what your options are, whether you're eligible, and if it's something that you wish to do. Or do you want to fight the matter, plead not guilty, and put forward as many defenses that are present, mistakes the officers have made, charter, contraventions, constitutional issues that will lead to an acquittal so you don't have to deal with these provisions. Thank you.